what I've done over the years. I started out as an industrial researcher, as an engineer, and working for a large US corporation in their research department, and moved into intellectual property because I found that it was very important to the research that we were doing to understand the IP perspective of things and to understand what we could learn from the huge database of intellectual property, particularly patents, that exists. And I then became an IP manager in that group, and subsequently did a postgrad certificate in IP law, and worked for a patent attorney firm, and now for pureLiFi. So I'll give you a little bit of background to intellectual property. We have a little exercise to do just to show how it can be important for very simple objects. And we'll talk about these 5 things: patents, designs, trademarks, copyright, and confidential information. There is one message which I would like you all to take away from today, which is how you can search for information in patent documents, and particularly how you can rapidly advance your own research and understanding by doing that. I don't think I spent, a couple of years ago, I spent over 1,500 hours doing patent searching for lots of different clients. I don't think there was a single client who wasn't amazed by what they learned when they did some patent searching. So, intellectual property, what is IP? It's something a form of property that's intangible. There's a little picture there of a plan with somebody's field in pink, and that's nicely marked out by boundary with lengths and dimensions. But intellectual property, the boundaries are intangible. They're not clear to see. They're often difficult to detect and to define, and also to protect. It depends on people's interpretations of words and what those mean. And it's also, as a result, quite easy to walk over somebody else's intellectual property protection without realizing it and without obviously having permission. So we're going to look at these 5 types of intellectual property here, particular attention to patents and designs, and have a look at briefly, very quickly, how valuable these can be in organizations and research establishments now more and more, and how the impact that they can have on commercial organizations. So these valuable things are just represented as this picture at the bottom of the right-hand side of the screen shows, just by bits of paper. Very, very briefly, because it's useful to understand this, intellectual property has been recognized for a long time in humans' endeavor. The US Constitution, for instance, gives the Congress the right to promote progress in science by protecting inventors with an exclusive right to their writings, the creative writings and their creative discoveries. So as a researcher, that's often quite difficult to conceive. One tends to think that research should be freely available for all for the progression of science. But in general, humans over the years have decided that it's better to give a monopoly right to people for the benefit of their creativity, as long as that monopoly right is not too excessive. So, for instance, the IP rights are all monopoly rights, but in every one, there's a check and a balance built in. For copyright, you're allowed to copy documents freely for your own personal use and for research. And for patents also, you won't be infringing patents if you're working in a research establishment and you're using what the teachings are within those patents for experimental use. The key thing to understand about IP law then is that it's based on case law, and that means that it changes every day as there's some decision made in some part of the world about somebody infringing, then the case law is revised. And the positive side of that is it means that the law is always up to date. It keeps up to date with massive technology advances, for instance, in the last 30 years. The negative side of it is it's very difficult to know exactly what the latest situation is in different countries and jurisdictions. So it's quite easy then, for that reason, to unknowingly infringe somebody else's intellectual property right. But we have an obligation, particularly in commerce, to make sure that when we're launching, sorry, my printer's objecting, to make sure that when we're launching new products, we are not infringing on somebody else's rights, particularly their patents, and that's known as freedom, having the freedom to operate. So do you have freedom to practice what you're intending to offer and sell? That involves, it's a difficult exercise, it involves searching through the art to establish that you're not infringing other people's rights. All these rights, of course, are also bounded by the fact that they're limited by time. So there's a 20-year time for patents, for instance. Very briefly, just to show you how simple products can receive quite nice protection. This is a post-it note. We're all familiar with these, developed by 3M in the sort of early 70s. But for something like 40 years, 3M have been successfully and profitably making these simple post-it notes. Their products considered to be the best in the market. And in terms of IP protection, you can see they have a trademark. It's called a post-it. They have 2 patents on the adhesive. It's an acrylic, non-adhesive, pressure-sensitive adhesive. And they have various designs registered for the packaging, for the shape of the paper, and so on and so forth. So a very simple product, which they've managed to sustain a very nice, profitable business on over 40 years because of their IP protection. And that's enabled them also to be seen as the market leader. Their products are generally the best ones. They don't curl up, the adhesive doesn't dry out, and so on and so forth. So the consumer has the opportunity to recognize that their products bring value, and they understand what they're getting when they make the purchase. In today's world, IP is valued very highly, very, very quickly. For instance, you might have a company that's, because of its shares, valued at $1 billion. It's got $400 million worth of factories and machinery, and the remaining 600 million is something intangible. It's what's in all the employees' heads, it's their trademarks, it's their patent portfolio, all these intangible intellectual property assets. And the reason that some of these values are now becoming very big is because, and the importance of IP is partly because of the amazing transformation we've had in the world in the past 50 years. Geographical boundaries have collapsed. Goods are transported freely around the world by overnight. And so IP protection gives innovation some defenses, enables companies to differentiate themselves, and gives them some sustainable growth for their innovations. What they develop is not immediately copied by somebody else, so they can continue to develop and research and maintain their market share. Innovating companies, therefore, are rewarded by being able to protect what they do, and they're able to survive. And that's important also in the information revolution, when we have such a rapid obsolescence of products. Here's very briefly, just to show you quickly and visually, these are patent grants over a period of time from the late 1800s up to today. You can see there's a sort of exponential growth more recently. And you can see also in the picture on the right that digital communication, which is what we're talking about today, has become very, there's an accelerating number in the last 3 years or so. So what does a patent look like? These are front sheets from a Chinese, a US, and a European patent application. Just simple bits of paper, something like anything from about 3 or 4 pages up to maybe 100 pages, describing an invention in figures and in text. And a patent allows somebody to have monopoly right over an invention. An invention needs to be something which is new. It needs to be something which is inventive. And inventive is difficult to define, but it's basically usually, or particularly in Europe, defined as something having an inventive step. Non-obvious in the US. An inventive step is basically by comparing what you have now in your invention with what exists in the current art. You enable an examiner to understand that there's been improvement in the knowledge, and that's considered to be an inventive step. So it needs to be industrial applicable. It needs to be in any field of technology, apart from a whole range of exclusions, like, for instance, scientific theories, mathematical methods, discoveries, and so on and so forth. So for academics, I've got what is a pitfall here for academics in relation to patents and research papers. And of course, the pitfall really is a lot of pressure to publish a research paper, sort of counter to the requirement to have not introduced an inventive concept into the public domain. So if you publish a research paper, it's likely to destroy your chances of having an invention. And as soon as something is disclosed without a confidentiality agreement outside of a research group or a company, then it becomes in the public domain. So yeah, so all patents are examined by patent examiners who will then determine if there's a sufficient inventive step and will give a granted patent, which will last for 20 years. This is a very brief illustration of a very famous patent court case. Americans came up with a windsurfing concept, but there was a small boy in England who had made a windsurfer, a basic windsurfer, that went against the claims of the US patent when he was 12. And he was able to prove that he had done that, and there was some witnesses to say they had seen him out in the public on the lake. And the US patent was there for null and void. So if from a sort of conceptual perspective, if you've been working on an idea and you think you have an invention, what's the first thing you should do? And the other point here, B, is if your company files lots of patent applications, but they're not getting very many granted ones, how can you improve that? And the answer to both of them is the same. You need to learn the skill of looking at the existing prior art, in other words, patents which are already published and out in the public domain. So I have here given an example of a free website. It's www.lens.org, where you can get a very reasonable tool to search, hundreds of millions of patents, or something like 100 million patents. It's quite a skill learning how to do that, and we don't have time to go through it today, but it's very useful for you at least to have a source where you can start experimenting and looking at areas which are of interest to you personally. You will find something that you didn't know, which will help you in your learning. It's a bit like not reading research papers and thinking that you can start a project and you alone as an individual or as a team will know everything. Would you start a PhD without a research paper search? Probably not. So I just like to refer to it as being informed and having informed decisions. So back to patents again then. You should always be doing prior art searches once you've got your idea. You can look and see, and you might save yourself a lot of time and effort by realizing somebody else has had exactly the same idea, or it might help you to improve your idea and write a better patent application. If you succeed, file a patent, get it granted, it is a negative right, and all it allows you to do is to stop somebody else from doing something. And that process is one where you yourself have to enforce it. So nobody helps you stop the other person. You have to write to them, you have to advise them that they're infringing, and you have to spend the money to take them to court if that's what you need to do, although it doesn't happen very often. Usually people, once you write to them, will stop doing what they're doing. I have a little question here at the bottom, which is to do with commercialization, because I know the talk was to be partly with that. And that is, what is it that can make a patent really valuable? And the answer is simple, which is that if you are selling a product which has a unique selling point, like it's the most sticky post-it note that doesn't dry out and doesn't curl up, then ideally what you should do is you should have your first claim of your patent referring directly onto the selling point. The thing that the strapline the salesman uses, the most sticky post-it note, the claim on your patent should say, should cover why it is the most sticky. Once you do that, you then have a direct monopoly over something which is valuable and which people are going to want to use and pay for. It's much easier to say than it is to do. This is a personal example, actually, of a project I was involved in loosely. We made an acquisition of a company in 2001, and our competitor filed a small family business. They just consistently filed over the next 10 years. A variety of good patents with good claims, and by the time it came to 2012, we had decided we could compete no longer with them, and we pulled out of that market. So a negative right to protect your creativity. Industrial designs are also protectable. They're much easier to work around, but they're useful for aesthetic three-dimensional shapes. For instance, here you can see the paneling on a Porsche Carrera. There's a kettle there. And of course, we talked about the post-it notes having shape designs. So design protection is for aesthetic designs. It's not allowed for functional stuff. And you can protect just part of the product or the whole product, as long as it's visible. It can't be a piece which is underneath or inside. For European registered designs, they must be new and they must have individual character, which means that they must create a different overall impression on an informed user. There's also a thing in Europe and the UK called an unregistered design. You do nothing. It's simply, you don't need to pay any money. It exists by default. It gives you a protection for 3 years of aesthetic designs, and it's very useful for industries like the fashion industry. On the other hand, a registered design for something like a Coca-Cola bottle might last you for up to 25 years, depending on which country. And once again, it's an exclusive right to protect your shape against from others making an exact copy. There are some big battles over design rights, even though it's quite easy to circumnavigate a design. You'll see lots of examples in the supermarket where various companies might, for instance, copy a bottle shape of Maxwell House coffee or something. So they've changed the shape slightly, just enough to reduce the individual character aspect, and they're effectively copying. This case that I've shown here at the bottom right was a famous one against Samsung from Apple, and the judge said that Apple's designs were understated with extreme simplicity, and he thought the Samsung designs were not as cool. Anyway, Samsung eventually won the case, and the outcome was that Apple had to publish on its website that Samsung didn't infringe. We'll talk briefly about trademarks. As scientists and engineers, we often tend to underestimate the value of a trademark, but they're very important and they can have huge value. The purpose of a trademark is to indicate the origin of goods, where they were produced, and this goes back for thousands of years. The Romans used to mark their bricks to show which legion had produced them. The concept is basically to help the consumer identify the source of the product, help them with purchasing decisions, and to encourage companies to maintain a good reputation. A trademark can be registered with an R, and sometimes you'll see a TM, which means it's unregistered. The company is using the mark, but they haven't actually registered it with the national jurisdiction that they're operating in. It can be a variety of things. It doesn't need to be a word. It can be a logo, a sound, a phrase, a color sometimes, and an image. And to show you the value of trademarks, the famous case of Rolls-Royce when it was first sold, Volkswagen purchased what they thought was Rolls-Royce. They bought the factory, they bought the people, they got the Bentley and the Rolls-Royce vehicle designs, they got the trademark for the grille, and they got the trademark for the Spirit of Ecstasy mascot, but they didn't get the trademark for the RR and the name. That was acquired differently at a different time later by BMW from the aircraft manufacturer, who's also originally the same company. And the aircraft manufacturer gave BMW the right to use it on motor cars. So BMW redesigned, built new cars, called them Rolls-Royce, and Volkswagen was forced to limit their productivity to Bentleys. I'll talk very briefly about copyright. It can be important. Sorry, I'll just click through these. Particularly in software, as a researcher, you're allowed to, software can be copyrighted. It's, again, one of these other entitlements that you don't need to do anything about. It's free. It's helpful to market as copyrighted, but you don't need to. And it's infringed by reproducing the work in a material form. It can be dramatic, covering dramatic works or musical works, and it subsists or exists for 70 years after the death of an author in terms of written works. You can use it freely for your research or your own use, but if you're using software licensing freely for research use and then you develop a product, you'll find that you can then be constrained because you don't actually have the ability to use the software which you originally used because it's covered by a use license for commercial use. And then finally, I did hear somebody mention intellectual property or confidential information in the end of the last call. Confidential information is quite often treated as trade secrets. It can be very, very useful if you think about the recipe for famous brands like Coca-Cola. These have never been disclosed in the public domain, and they've existed secretly for years, allowing Coca-Cola to continue to be a market leader. So it's all sorts of information about the way things are made or sold. And it can be protected and shared as necessary via legal agreements, collaboration agreements, confidential disclosure agreements, employment contracts, and so on and so forth. Some companies use a philosophy of need to know, so it's only people that need to know something to do their job that get to know the information and train their people accordingly. There are other organizations who believe that information should be freely shared in order to push forward science rapidly, and I think there's a happy medium somewhere in between there. You both want to push, you want to collaborate and push forward research as quickly as possible, but then there's also, I believe anyway, a need to have some balances about protecting what it is that's creatively generated as a group. And so that is my very brief talk on intellectual property. I've just managed to squeeze it into about 25 minutes. I've given some useful links at the back here about where you can find information on various, the European Patent Office, US Patent Office, and